DCC Judgment 112 宪判 Night 2023 Case on the search and seizure in respect of a law firm's offices. High notes. Article 122, paragraph 2, and Article 133, paragraph 1 of the Code of Criminal Procedure were declared partly unconstitutional for failing to provide sufficient procedural safeguards for attorneys and law firms. The provisions did not exclude attorney-client communication of attorneys and law firms from search and seizure, consequently violating the lawyer's right to work and their client's right to judicial remedy. However, the current mechanism of judge-reviewed warrants and challenge procedures against the search and seizure are sufficient in terms of judicial supervision and remedy. Background notes. This judgment concerns the attorney-client privilege and the protection of professional secrecy of lawyers in cases that involve search and seizure in respect of a law firm's offices. The disputed provisions are Article 122, paragraph 2, and Article 133, paragraph 1 of the Code of Criminal Procedure. The former stipulates the standard to initiate search and seizure toward parties that are not criminal suspects, the latter the general regulation for seizure. I will skip the background facts here. Summary of the judgment. Holding 1. Article 122, paragraph 2 of the Code of Criminal Procedure provides that the person, property, electronic record, dwelling, or other premises of a third party may be searched only when there is a probable cause to believe that the accused or the suspect or property or electronic record subject to seizure is there. Article 133, paragraph 1 of the Code of Criminal Procedure provides an item which can be used as evidence or that is subject to confiscation may be seized. Upon comprehensive examination of the two provisions and other relevant regulations, it is observed that documents, papers, electronic records generated by lawyers or defense counsels in the exercise of their constitutionally protected right to confidential communication with defendant, suspects, or potential suspects are not exempt from being subject to search and seizure. Within this scope, the disputed provisions violate the protection of a lawyer's right to work and the defendant's right to judicial remedy under Article 15 and 16 of the Constitution. The competent authority should amend the Code of Criminal Procedure following this judgment within a 2-year grace period from the announcement of the judgment. Before the amendment, search and seizure conducted by judge, prosecutor, and the relevant authorities should conform to this judgment. Viewing comprehensively from the disputed provision and the other regulations regarding search and seizures, judges may review such warrant application from relevant authorities. There are also established supervision and challenge mechanisms for the order and the execution of search and seizure. Therefore, the Code of Criminal Procedure not providing a special procedure for the search and seizure in respect of law firms does not violate the protection of freedom of residence, lawyers' right to work, due process of law under the Constitution. The rest of the petitioner's complaint is dismissed.